Hi, everyone, and welcome to another episode of Orrick Live. In today's episode, we are going to get a little deeper into issues related to bringing on employees and consultants and advisors, something that every company goes through from very early stages. And we thought we can maybe explore some of the issues and some of the considerations that should be kept in mind. So joining me today is one of our partners from our employment team based in Sacramento, Anna. Anna, thanks for joining us today.
Thanks, Aria. I'm happy to be here.
Yeah, so Anna's a specialist in all things related to employment, including onboarding and termination of employees, as well as everything in between. And Anna, before we get started, I believe congratulations are in order because you were recently elevated to a partner here at Orrick. So congrats.
Thanks, Aria.
Well, hopefully this means that I'm scoring the first ever world exclusive with you as a partner.
I think you are.
Okay, great. All right. So we'll take that as a win for the show. So let's get into it, Anna. I thought maybe we could start with some basics. So let's start with just when a company is trying to hire an employee or bringing on a consultant, what should they think about? Like, what are some basic considerations? Should there be offer letters? Should it be less formal? What do you think?
Yeah, I mean, these types of nuts and bolts issues are really great for companies to consider because the way in which you onboard employee number one is going to be consistent with the way in which you're going to be onboarding the rest of your employees. And with respect to documentation, most definitely the best approach would be that you onboard the employees with an offer letter that sets out the terms and conditions of their employment, including things like compensation, what their benefits will be, critical provisions like the employment being at will, any other conditions, like if you don't want them to be working out and engaged in outside activities that are competitive to the company, that it be a condition of employment that they sign the company's standard invention assignment agreement. And then other just legal conditions like having the proper authorization to work in the US. All these things would be typical terms within an offer letter, and most definitely to the company's benefit, that there's agreement with the person as to these terms and conditions before they onboard with the company.
Okay, great. And offer letters, is it like one size fits all, or should everyone from like down to the mailroom, to the extent people have mailrooms anymore, to the C-suite, everyone gets the same thing, or what do you suggest usually?
Yeah, so most companies are going to have their standard employee offer letter for standard employee hires. But in the event that you have a critical employee hire or an executive level employee hire, there may be some special terms that get included in the offer letter, such as provisions around severance that you would pre-contract for, maybe acceleration rights in the event of a change in control coupled with a termination. And so there will be those types of special provisions, and most definitely when you are considering those special provisions, including something as simple as what you might think is simple, like a signing bonus, you should work with counsel because wording will matter. I've had situations when a company had wording around a signing bonus that they wanted to have a clawback right, but it wasn't phrased correctly, and so they didn't retain that right. And please partner with us when you have special provisions to make sure that the provisions are drafted in the way in which are in the company's best interest.
Right. Yeah. So I guess for most employees, at least at the early stages, there will be just the standard form of offer letter that doesn't have any of these bells and whistles. I don't think, my experiences, and I'm sure yours, because we work together a lot, is most people don't get severance rights. Most people don't get these acceleration provisions. That's really for the more senior executives, at least at the early stages. So so I think for key people, the message here is that there needs to be sometimes additional thought given to it. So don't just take the standard form and give it to people always.
That's exactly right. And then one other thing, Aria, that I wanted to add is, with respect to offer letters, when you are bringing on a sales employee, additional terms that you'd want to include, because many states require commission plan terms to be in writing in a written agreement between the employee and the company, that you either have a commission plan that you present the employee with soon after they're hired, that they'll sign on to if you have more than one sales employee and a plan makes sense. Or if you're doing your first sales employee hire, maybe you'll include that individual's particular commission plan terms into the offer letter as an addendum. But in any event, I did want to flag that for your sales employees, along with the standard offer letter terms, you will need to have crystallized terms around commissions, like when commissions are earned, when they'll be paid, and what will happen to commissions at termination and how they'll be calculated.
Yeah, that's a great point, because a lot of companies actually don't ever formalize a commission plan at the early stages, and it could become a problem. I think it's best to have that in place for sales employees for sure.
Absolutely.
So that's great. So here's another question that people usually ask. And the reason they ask it is because having an employee comes with all these other things you got to do, like you got to pay payroll taxes, and then there's like wage and hour laws and things of that nature. People will say, well, why don't we just sign everyone as a contractor, And then some people do it, right? I mean, famously, some big companies out here in the Valley have maybe done it. So why not? Why can't everyone be contractor? What's the issue with that? Seems simpler, doesn't it?
Yeah, unfortunately, the issue is that the legal presumption is that whenever you have a worker that works for the company, the law presumes that that person should be an employee. And then the burden will be on the company to the extent you want to engage that person as a contractor as opposed to an employee, for the company to defend and establish the legal criteria that person can be classified correctly as a contractor versus an employee. That the criteria is state law driven, and there are states like California and some other states that have adopted what is called the ABC test. That is like more stringent in terms of justifying a contractor classification. There are other states that use a common law totality of the circumstances where you're going to look at multiple factors. But in any event, unless you're able to defensively fit the worker within those categories, if you face a litigation as to misclassification, the company would have an uphill battle in terms of defending against that type of lawsuit. And if to the extent companies scale using that onboard employees as a contractor and then convert them to an employee. So I've had companies tell me, hey, it's the try before you buy type model. If you have multiple employees that you've onboarded in that fashion, that number can result in potential multiple plaintiff or putative class action risk to the company if that's a model that you've institutionalized.
Yeah, it's definitely one of those problems that could really become a problem, especially if you get big enough, the company gets big enough and successful enough, and then people might actually start suing for that. So definitely better to avoid that issue early on. And investors ask about that. I mean, we don't want to be sitting here and say people never do it. People do it for sure. It's a risk assessment at the end of the day, but we suggest that at least for key employees, it be done properly, but preferably for everybody. So another quick question while we're talking about these employees, which might come up for certain types of businesses. What's the difference between exempt and non-exempt employees?
So thanks, Aria, for raising that issue. I would say, pretty frequent in terms of wage and hour issues that we deal with for early companies is that contractor versus employee classification issue. And then the other classification issue that we deal with is the exempt versus non-exempt employee classification issue, where that can also give rise to potential litigation risk for our clients. But like I mentioned, in terms of legal presumptions with respect to independent contractors, the law also has with respect to your employees, the presumption that everyone is non-exempt. What does that mean? That means that everyone is eligible for overtime at the applicable overtime rate for any overtime hours worked, unless they fall within federal and state exemption, which will enable the company not to pay overtime and can pay the employee on a salary basis, where you're looking not at the number of hours the person is working, but just the deliverables being provided by that exempt employee. And what are kind of like the common exemptions that we deal with for our type of client base? We might see the administrative exemption, where someone's functioning within the GDNA function, like your finance person, your HR person, but who is entrusted with dealing with matters of significance and exercising independent discretion as to such matters over a majority of the time. Other exemptions that we might see is the executive exemption, where you have someone directly supervising 2 or more employees within a department. And then we have, a common software engineer exemptions, but please check with us because certain states like California have a different salary threshold that you must pay in order to fit your software engineers within that exemption. And then you may have in instances the sales exemption, but it's a hard exemption to make, and it's super technical. So again, in that context, when you have sales employees, please consult with counsel.
Yeah, that makes sense. And I guess we should say that wage and hour regulations are just Department of Labor regulations, I believe. Is that right? And then they just govern the things that you talked about, which are minimum wage or minimum salary, and how many hours you can work without overtime, how many breaks you need to take, and things of that nature, right?
That's right. So you're going to deal with a couple of different regulatory formats when you deal with wage and hour type issues. So you have the federal law, which is the Federal Labor Standards Act, and then many states have their own state version that has, like in for example, in California's case, more stringent laws than the FLSA. And then you may have like the agencies, like the Department of Labor for the US law, or the respective state agency coming up with additional regulations under the legal statutory format. And so there's just different overlays of laws in place, and can be technical in some respects, like black and white, and in some respects gray in terms of like which classification applies. But for that reason, you should check with counsel and work with us on these types of common wage and hour issues to make sure that you're in compliance.
Okay. Yeah, definitely not to be taken lightly. Let's switch gears here and maybe talk about something that I'm sure everyone is to some extent doing these days, and which is remote work. I mean, I'm here in the office. You're not. We're talking over the Zoom, and this happens everywhere at this point. What should people think about before, or if they want to allow employees to work remotely?
Yeah, so location is going to matter. I'm going to kind of split it into 2 types of remote employees. So your remote employees who are located somewhere within the US, and then your remote employees that decide to go elsewhere outside of the country. With respect to your US-based employees, if they're working remotely, you want to make sure that you have their correct residence on file, and that you are registered as an employer of record and properly running payroll through that employee's state of residence. I've had situations when a company hasn't updated an employee's residence, and that might result in payroll issues if you're running state withholdings for the wrong state. And then separately, if you have not registered as an employer for that state and followed all the other associated requirements for being an employer, that can also create potential issues with the state or penalty type situations. And so that's going to be important for you all and for your remote employees. Telling them, look, if you change locations, you need to get prior advance notice and permission approval by us. before you change locations so that you are properly set up to run payroll. Like I've had situations, for example, when an employee might go to a jurisdiction where it's more difficult for an employer to set up and register as an employer of record, delaying payroll, and that's created separate potential risk issues for the client. And so for that reason, it should be a directive to your remote employees that they understand that they need to get that prior approval prior to them moving. But other than that, to keep in mind is each state has its own employment law regime. And so, with respect to things like employee leaves, sick days off, those types of employment related benefits, the law in which the employee resides, it's typically the law that protects the employee. So you may have employees in states like California and New York that have pretty established complex laws for employees that are protective of employees. And so you just need to make sure that there's that compliance issue that you think about with respect to kind of your day-to-day employment law issues. More complicated.
I just want to highlight something you said, Anna, sorry to interrupt, which is, I think, important to keep in mind that it's actually the law of the state where the employee resides that applies to that employee and what you need to do in terms of all the things you mentioned, not where the company was incorporated or is headquartered. So you could even hire someone here in California, and if they move to Utah, then you got to think about Utah law for the employee that moved there. I think that was a really good point. But yeah. Sorry, continue, please.
No, thanks for flagging that, Aria. That's definitely an important issue, and where I've had situations that arise from time to time is like for a company that might want like a customer non-solicit post-termination or a post-termination non-compete, and they may say, hey, we're going to rely on Delaware law to try to get these provisions in, but the employees in California, which is staunchly anti non-compete provisions, it's a risk to the company because one, California law prohibits you applying another state's law unless the employee is individually represented by counsel with respect to the negotiation of that agreement, and may subject the company to penalties and the like. And so, when you have those types of provisions, you should make sure that you keep in mind exactly what Aria flagged, that generally speaking, it's the law in which the employee resides that is going to protect the employee.
Yeah, absolutely. And I think all these issues get bigger and more complicated if you have employees outside of the US. Then you really got to think about, and especially in Europe, for example, that have different regulatory directives in place. So I think it's important to understand what happens if you start hiring people. I mean, talent is global these days, but I think founders and executives should remain mindful of all the pitfalls and really have a plan for how to deal with it, even if that plan means, hey, we're just going to take some risk here, but at least know the risks that you're taking so it doesn't catch you offside. One other thing I wanted to get your thoughts on here, Anna, are interns, because a lot of college students are looking for credit, willing to do some work to get experience, and obviously that's good talent for the companies too. How should companies go about getting interns?
So for interns, the general rule and operating principle that for-profit companies should keep in mind is that it is very difficult to have an unpaid internship. If you are a nonprofit, you can have volunteers or unpaid interns or unpaid workforce, but the legal standards around unpaid internships for a for-profit company is pretty stringent and limiting. And so to the extent you're going to have an unpaid intern, you should make sure to work with us to confirm that the internship falls within the permissible legal standards for an unpaid intern. But typically, the main consideration that you would look at is who is the primary beneficiary of the internship. Is it going to be the intern who gets a meaningful vocational learning experience at the cost to the company in terms of time and resources, or is the intern being brought on to displace what a paid employee would otherwise be doing? And then, and that's in the category of unpaid interns. But with respect to paid interns, it's just semantics. What a paid intern is essentially a temporary paid employee, and so they would onboard with your standard confidential information invention assignment agreement. You may have an offer letter that's a more scaled down intern offer letter. But for all intents and purposes, notwithstanding the title intern, they're just going to be your employees. You're going to make sure that you pay them, on an hourly basis, the applicable, at least the applicable minimum hourly rate, and that they be overtime eligible.
Got it. I know I said that was going to be my last question, but I actually thought of one more question I really want to ask you, which is, everyone talks about how U.S. is an at-will jurisdiction, which I think is quite unique in the world from what I've seen. What does that mean? And does that really, I guess I'll tell people maybe what that means is my understanding is you could theoretically let anyone go without notice at any time, and they could quit at any time without notice as well. But is that really what happens? Like, can people really let people go like on the spot? And how does it usually play out in the real world?
So yeah, in some respects, like at will is a misnomer because it creates a misconception that you can terminate employees for any reason. I mean, that is a legal standard that you can terminate an employee with or without notice for any reason, and an employee can likewise resign at any time with or without notice for any reason. But what's unstated, but definitely there in terms of applicable legal concepts, is that you can terminate an employee for any reason, provided that it's not for an unlawful reason. And so that's how you're going to end up in a situation where an employee claims things like discrimination or retaliation with respect to a termination. I frequently have this conversation with clients where clients will say, hey, employment is at will. I can terminate that person. I don't know why they're claiming retaliation. And then I have to explain that, yeah, employment is at will, but the employee can still argue that the termination was for some unlawful reason, like a retaliation for them having raised complaints during their employment. So you just need to make sure that that kind of overlay of restrictions on unlawful actions by the company exists with respect to at will. Most of the states in the US are at will, but Montana is not an at-will state. So if you're going to prepare an offer letter for Montana, definitely work with us to make sure that you've incorporated provisions that specify and track against Montana law to reserve the company's right to terminate an employee. Also, Puerto Rico is not an at-will place of residence, and so you would want to make sure that you work with actually Puerto Rico Council, because the laws are pretty complex there, so that the offer letter is set up correctly in terms of reserving termination rights to the company.
Interesting. So fans of Yellowstone, take note about Montana not being at will. And that's exactly why I suppose when people leave, companies try and get a release of claims, which means that they have to pay some sort of severance payment to those employees. And it's exactly because of what you said, that there could be claims, even though the employment was at will, there could be claims that get brought. So it's just cleaner from a company perspective to sometimes get people to agree that there are no claims and they're going to waive all those, and then they just get a few weeks of usually salary as payment. And for more senior executives, I assume that concern is even more alive. So and that's where you get into negotiation of larger severance. Okay, Anna, I know we're running short on time. Any final thoughts? Anything you think we should absolutely talk about?
No, I think we kind of covered like the general nuts and bolts of hiring and considerations in terms of onboarding employees and termination of employees. But definitely, I just wanted to note that we're here for you. We're happy to help you in terms of putting in the right processes that you can use to scale up your workforce and have comfort that you've done it right, so that it doesn't become a problem later.
Okay, amazing. Well, thanks so much for sharing your thoughts and taking the time to join us, Anna, for this episode. And definitely hope to have the chance to chat again. And I'm glad that I was the first to interview you as a new partner.
Thank you so much for the invitation. I enjoyed talking with you through these employment law topics.
All right, thank you.